Live from Chattanooga, Tennessee, it's Nooganomics with David Tulis.
Is the state bound by law or is it not? That's the question that the effort now underway to bring into our statutes the Tennessee Natural Marriage Defense Act asks. Is the state bound by the law or is it bound by the whim of elected officials such as Bill Haslam, our governor, appointed officials such as Herbert Slattery III, both men Presbyterians and Presbyterian elders out of Knoxville? Are they bound by the law of God? Are they bound by the Constitution, which chains them to the rule of constitutional government, allows them to be servants of a free people? In our Constitution, we're described as a free people in what we also call a free state. We have a free state. We have what's called free government. These are terms out of our Constitution. And what free means, they're not bound by individuals. They're not bound by interests. They're not bound by cabals or groups or combinations. They're bound by the clear and bright rule of law, which imposes a limit upon the government and also upon the state. Here in Tennessee for the legislative session is Cal Zastrow. He's from Bay City, Michigan, and he has gotten greatly interested in a very important volume that I'm holding up here for my viewer on YouTube. It's The Doctrine of the Lesser Magistrates by Matthew Trewhella. It's a vital law book. This is a law book that has a great deal of history and an explanation of how it is that a lesser official, let's say Bill Knowles, our county clerk, how a lesser official can stand in defiance in good faith and in the law of a greater official who is ordering him or making suggestions that he violate his oath to the Constitution and violate the Constitution itself. Well, Cal Zastrow, what is the remedy to Obergefell versus Hodges, the poofter and lug butt opinion, as I call it? Lug butt is LGBT. What is the remedy to this poofter decision out of the third branch of the federal government? What are you proposing?
Well, what we're proposing is for Tennessee and all other states to just uphold the law. Courts do not make laws. The Congress makes federal law. State legislature makes state law. And elected city officials make city ordinances. So policemen cannot pull you over and while you're driving your car and say, hey, you got a bag of Kroger groceries in the back seat. I want those. Oh, and you were speeding? Okay, I'll shoot you in the foot. Elected officials, appointed officials are responsible to uphold the law. Not what their opinion is, not even what a court opinion is. They're responsible to uphold the law. So currently what's happening is the U.S. federal court, the Supreme Court out of Washington, D.C., 5 out of 9 judges have said that the Constitution of Tennessee, in fact, no state constitution has any merit whatsoever if you define marriage. We are going to define marriage, and we define marriage as whatever you want it to be. Doesn't have to be a man and a woman. Like your Constitution says, it can be a man and a man and a woman, or who knows what else they're going to go for soon. So what we're doing here in Tennessee is there's been legislation introduced. Mark Pody in the House and May Beavers in the Senate have introduced the Tennessee Natural Marriage Defense Act, House Bill 1412, Senate Bill 1437, which will say that we will uphold the law here in Tennessee, and we do not recognize this Supreme Court decision as canceling out our Constitution and canceling out our laws. We're going to continue to uphold the law.
Well, my listener has
excellent.
We're talking with Cal Zastrow. My listener has a question, and the question is this: if we have a Constitution that says we are a state in which marriage is recognized, why do we need a bill to say the same thing? How is a bill going to enforce or encourage or make mightier and brighter our Constitution, which already is unmistakable on the point of marriage?
Well, what we're doing is we're mobilizing and unifying the whole state together. Like in Kentucky last September, when the federal judge threw the county clerk, Kim Davis, in jail because she would not break the law and issue marriage licenses to homosexuals in Kentucky, he just threw her in jail. He had no law. He just threw her in jail. So what we're going to do is we're going to say that the state of Kentucky will protect, will defend, will pay for, and will provide for the county clerks who uphold the Constitution, who uphold the law. If the feds come after them, if a federal judge or federal marshals or whatever come after us in Tennessee, then we are uniting together as a state to defend them. That's what is necessary, and that's what we're going to do. Well, we should have already been doing that, but what we're doing is we're mobilizing the state legislature right now to clearly say we're going to defend, as a whole state, we're going to uphold our Constitution.
So the bill is a sign of resolve. There's a bit of history in this bill. It talks about various efforts in American constitutional history to reject lawless opinions and for states to kind of go their own way as against rules by the federal government. This is David Tulis, and we're going to be doing a special report at 11 today on lies, deceit, and county cover-ups. We're going to tie in the impact of social media and sexual abuse in the public school. We have a call coming in. Hang on. This is David Tulis. You're on the air live with Cal Zastrow, who is here defending the Tennessee Natural Marriage Defense Act. What's on your mind?
Great topic. I have a couple of comments, though. First of all, I'm against homo marriage. There is no such thing. Secondly, I'm so happy the Supreme Court ruled the way they did, because they ruled the correct way. You're on the wrong side of the law. States have no authority to issue licenses. When is the state going to get that through their head? You can't issue a birth license the common law way. You can't issue a marriage license. The Supreme Court was absolutely 100% correct. If the state is going to issue licenses, which is permission to do something that was otherwise illegal, they cannot, under the 14th Amendment, which applies to the states, to the Bill of Rights, discriminate against a class of people who the government deems to be protected. You're going to lose. You're going to lose.
All right. What is the answer to that objection? That the comment is, you my listeners, that the Obergefell versus Hodges decision is correct, because if the state is going to issue any license at all regulating something which is a common law right, then it really cannot discriminate in favor of male, female marital unions.
I'd be all in favor of going back to the common law on that. But what happens is the state of Tennessee is responsible to recognize and uphold their Constitution. The state of Tennessee is responsible to define what they do. The federal government must stick to their enumerated powers. And when they step outside of those enumerated powers, then that's become lawless tyranny. And the federal Supreme Court cannot trump state constitutions, and they can issue opinions and they can issue directions, but they cannot cancel out state constitutions and what people do in the states. So if the state has always been involved in families, it's always been involved, because when there's problems and breakdowns, those things happen. The state cannot give permission for people to marry anymore. They can give a baby permission to be born, but they can recognize and protect the entity of marriage between one man and one woman.
So we would say, even though you and I, Cal Zastrow, object to statutory marriage in concept because it's a form of theft by the state against the people, where they're told they can't exercise a common law right, we would say, okay, they have stolen it, but now that they've stolen it, let them reflect a biblical order, allowing only a man and a woman to marry.
Right, and they've way overstepped their bounds, because the state Constitution defines what marriage is, and will protect and uphold that against fraud things. The federal court needs to, in the Obergefell decision, sir, you said that you agree that they ruled correctly. They did not stick within the constitutional confines. Instead, they quoted Cicero and they referred to Confucius. I have a big problem when courts quote and cite sources and people like that, instead of sticking to their enumerated powers and issuing their rulings based upon what their job is in the Constitution.
This is David Tulis. We're talking with Cal Zastrow from Bay City, Michigan, here to help Tennesseans bring about an affirmation of the Constitution. It's called the Tennessee Natural Marriage Defense Act, sponsored by Beavers Pody. It's called the Beavers Pody Bill, if you need a shorthand reference to that. Now, Cal, you're operating on a presupposition that there is a law, there is a kind of a human law, and that law is called the doctrine of the lesser magistrates. It arises in great form as an argument from the Reformation, but it's really a biblical argument, and there are precedents for it even prior to the state of Israel, even in ancient times. What is this doctrine of the lesser magistrate? And let's give me your answer in terms of Bill Knowles. Bill Knowles here in Hamilton County is our county clerk, and he violated his oath of office, I think. I would like to suggest that in yielding to the Poofter mudslide. What is Bill Knowles' authority? What does he have authority to do as a clerk? Tell about this doctrine in terms of his office here in Hamilton County.
Okay, Bill Knowles has taken an oath to God. He swore to God to uphold the Constitution, to uphold the law, and to uphold the Constitution of Tennessee. He swore an oath to God to do that. And so what happens is the Supreme Court comes along and says, we order you, or our opinion is you should break that oath and go with our opinion. You should break the law and go with our thing. What we're asking him to do is to stand and do what's right, to obey the Constitution, to continue to do what's right. That's what we're asking.
Well, he might get sued. He might get sued, Cal Zastrow. Someone might sue him.
That's right. And also the Supreme Court might say that we suspend the law of gravity, that our opinion is more stronger than that. We order you to jump off the Grand Canyon, and we're going to sue you, and we're going to send federal marshals if you don't obey our opinion. That's where he's not alone. That's where the exciting thing about this bill is one county clerk may get sued by the feds or have problems with that. But then the exciting thing is the whole state of Tennessee, and hopefully the churches and the people of Tennessee will rally around whoever gets picked on by the feds on this.
Well, let's say that Hamilton County indeed had a godly and fearful county clerk. What would be the duty of the sheriff, Jim Hammond?
The sheriff should protect all citizens under their jurisdiction that are innocent. So if the sheriff knows that people are coming to kidnap a little child, or federal marshals are coming to unlawfully kidnap a county clerk, it's the sheriff's job to defend those people. And it's we the people's job to stand with them and show up.
With both of them, because here in Hamilton County, both Bill Knowles, the clerk, and Sheriff Jim Hammond are elected. They are constitutional officers.
That's correct. They are elected, and upon before beginning of their duties, they swore an oath to God. That's not just saying, okay, I'll try. They said they will obey the Constitution. They did not swear an oath to obey court opinions. They swore an oath to uphold the law.
Well,
certainly they're not doing that.
When you bring that up, that there's something I wanted to suggest to the listener. The oath of office is important. It's not just something that's pro forma, that's done just for appearances. It means something. When does it mean something? It means it's important when there is a threat to the Constitution through that office. And so at the very point where the threat is the greatest, here on what is marriage, the clerk has to stand, not on unimportant things so much, but where it's important. Here, there's a challenge to his duty. The duty is you record lawful marriages. You declare in the record that this man and this woman are lawfully married. And here now we have an opinion that says, well, you can say that two men are married and record that. You can actually record a legal document in our county called a license that says two men can marry. How can that be done in good faith by a man, even a man who's not a Christian, who takes that oath? How does that work?
Well, they can't uphold their oath and continue to do that any more than someone can bring in their taco and say, I want a marriage license for me and my taco. You cannot do that. That's why we elect people and we expect them to follow the Constitution. We are a nation to be ruled by law, not by lawless opinions, not by dictators, not by gangs of bandit warlords that threaten and bully us.
So no one in public office, Cal Zastrow, here in Tennessee to help this pro-marriage effort, no one who takes an oath of office should do so lightly. He should know that God is going to hold him to what he promises to do. And that is what?
They have taken the oath to uphold the Constitution, to obey the law, to do what their duties prescribe, to be a public servant that way, not to make decisions that violate that oath.
Now, are there any legislators, Cal Zastrow, in the Chattanooga area whose constituents need to hear from those constituents about this measure? What's happening in the legislature right now?
Well, what's happened is the bill 1412, the Tennessee Natural Marriage Defense Act, that is coming up for a subcommittee hearing next Wednesday. In fact, out of East Hamilton County is a Representative Carter, and he is on that subcommittee. And we would just invite people to contact him and respectfully ask him to uphold the law, uphold the Constitution, and support this bill. That's what we're asking him to do.
Say something about the bill and what the contents are. It runs several pages. It's kind of a history. What are some of the historical precedents for this doctrine of the lesser magistrate? In the view of this bill, the lesser magistrate is the state of Tennessee itself, as against the good people in Washington. What's the history of this idea?
You're generous with calling him good. The history of this is, for instance,
I don't want my listener to hate them.
Right. We're not to hate people, especially those that profess to be Christians. We're to love people and help to educate them of the right way. The history of this, in a real brief summary, is when the U.S. federal court issued their Dred Scott decision in the 1800s, saying that African Americans, Black Americans, that they were not guaranteed rights because they were not considered persons. Okay. Immediately, the Supreme Court of Wisconsin and the legislature of the state of Wisconsin said, we will not recognize that, and we will continue to treat these people as persons with all their lawful rights.
That was 1854.
1854 was the Dred Scott decision. And so they just did what's right. They said, your opinion is wrong, and your opinion is not constitutional and is not lawful, and we will continue to do what's right. And they did.
And the bill goes on to say the Wisconsin legislature back in those times, the 1850s, in response, passed a series of resolutions denouncing the actions of the United States Supreme Court as, quote, an arbitrary act of power without authority, void, and of no force, and urging, quote, positive defiance by the states as the, quote, rightful remedy. So your suggestion is that this bill brings to the mind of Tennessee's representatives the duty they have to the law.
That's right. A positive, and I would add one adjective in there, peaceful. Positive, peaceful defiance. We're not going to cooperate with them in their lawlessness. We are not going to be lawbreakers with them. We are going to just simply uphold the law here. That's what we're asking people to do. Uphold the law, do what's right, obey your oath of office, and let's see what happens from this. Let's see if Tennessee leads the entire nation in coming back to lawful liberty.
It's interesting, Cal Zastrow, how one person can do this. Often one person, as in the overthrow of Ceausescu in Romania, came from one minister who refused to do something demanded by the state. And he was surrounded by his members of his church and then the people in the town. And finally, there was a kind of a counter-revolution against that total surveillance state with its jails and its torture chambers. And Ceausescu was slain by the people at some point. One man often is the start of it. So one man standing on principle at that moment, really entirely alone.
More important than that, Pastor Laszlo up in Timișoara, Romania, when the secret police were coming to get him, it was more than one man. It was one man who led one church. Okay, it was his church that came and peacefully surrounded him, peacefully interposed between the tyrants and the innocent person, the innocent pastor. And then when that's where the Romanian Revolution started, was when one man stood and one church stood.
But I really think, Cal Zastrow, what's proposed here in this bill by May Beavers and Mark Pody, the Beavers-Pody bill, it's really not revolutionary. It's barely, you could say in a way, it's counter-revolutionary, and it's really, these interpositions are very mild. There's great mildness in this idea of the doctrine of the lesser magistrate.
Dr. Martin Luther King Jr. said, we will wear you out with our ability to suffer. We will defend our rights, and we will do it peacefully, and we will suffer until we get them. Now, all county clerks here in Tennessee have abandoned the law, have abandoned their duty, have abandoned their rights, and we're calling them to come back and do that. And we'll say the state of Tennessee will stand with you in cooperating with that. We also invite people to come up next Tuesday. We're having a rally at noon in front of the state capitol. Representative Mark Pody and the other co-sponsors of the bill will be on board to speak to us.
Is there a website that my listener can go to?
Yes, please go to courtscannotmakelaws.com /Tennessee for all the exact
Okay,
Details of what's
courts.
coming up.
Here's the website again. Courts cannot make laws, plural. .com, and then / Tennessee. So you can find out
yep.
TN. So you can find out there about what's going on. And that is an event that is coming up on Wednesday. Well, the event is Tuesday.
The rally is Tuesday, and the subcommittee
in Nashville
is Wednesday in Nashville. So we invite people to come to both if they're able to, and be a part of history. Let's do it. Let's lead the nation in upholding the Constitution against this lawless tyranny.
One man can do a lot. One man, and you, my listener, maybe are that man. Representative Carter, might need to hear from you. Do give him a call. Don't think that this is a matter of indifference. Thanks, Cal Zastrow.
Mr. Leon, let those boys have a bud.